Now we'll open a public hearing on House Bill 4138.
Chair Krupp, Vice Chairs Wallen and Choatson, members of the committee. House Bill 4138 creates new rules around law enforcement identification and prohibition of law enforcement facial coverings, restricts how and when public bodies in Oregon can cooperate with out-of-state law enforcement, and creates a cause of action and a violation offense related to violations of the requirements. The measure declares an emergency and is effective on passage.
Chair Krupp, Vice Chairs Choatson and Wallen, and members of the committee. For the record, my name is Farah Chaichi, and I have the privilege of representing House District 35, which is one of the most diverse districts in the state, Beaverton and Aloha. I'm here today to speak on behalf of HB 4138, the Law Enforcement Accountability and Visibility Act. Colleagues, we're being called on by vulnerable members of our community to do something to protect them. We must respond meaningfully by passing legislation that creates a firewall between rogue federal agencies and scared Oregonians. That's what this bill, LEVA, does. I'll keep my comments brief because in this moment we need to prioritize the voices of experts, including those with lived experiences who are in fear of ICE. Right now, masked agents are terrorizing immigrant communities with impunity. Federal agents are obscuring their identity and refusing to identify under whose authority they are acting when they rip people from their cars, lurk outside of schools and workplaces, and kidnap folks off the street. LEVA would require that all law enforcement agencies operating in Oregon have clear identification, both of individual badge numbers or names and jurisdictions, a standard that many local police agencies already follow. In addition to identification requirements, LEVA also strengthens the protections set forward by Oregon Sanctuary Promise by mandating that public bodies who receive requests for information or data from law enforcement agencies may not turn over that information without legitimate cause and assurance that the information shared will not be used to violate the rights of individuals. This is critical, not just in establishing protections for our immigrant neighbors, but also for any Oregonian engaging in protected actions that are being targeted by the federal government. There is a long and grim history of state agencies being weaponized by the federal government to target activists, community organizers, and marginalized people. This bill would establish a firewall and additional checks to ensure that Oregon, our local law enforcement agencies, and public bodies are not unintentionally contributing to the targeting and terrorizing of vulnerable people. LEVA establishes a pathway to injunctive relief to ensure that community members are protected against violations of their constitutional rights by the federal government. It is imperative that we rebuild the broken trust between community members and their government. My team and I have worked tirelessly to collaborate with advocates, community partners, local law enforcement, local agencies, jurisdictions, to craft a bill that meaningfully responds to the moment we're in while honoring the work already being done by these agencies to promote trust and cooperation in the community. I really want to thank everyone for their helpful and constructive and meaningful feedback on this. Thank you.
Thank you, Representative. Michael?
Thank you, Representative Chaichi. Chair Krupp, Vice Chair Wallen, Vice Chair Choatson, and members of the committee. For the record, my name is Michael Abrams, and I serve as Policy Counsel for the ACLU of Oregon. We are honored to be presenting this legislation to you today and grateful for the partnership and hard work of many. Stakeholders, including our cities and counties, law enforcement, state agencies, and public universities, have provided valuable feedback and thoughtful analysis. And community members and organizations, particularly those most impacted by the actions of rogue federal agencies, have been integral to developing these solutions. We have simplified the officer identification and masking requirements while continuing to apply them to all law enforcement agencies operating in Oregon. Officers may not generally wear masks, and they must display their agency affiliation and name or badge number on their uniform in one place. The only change to HB 3355 from 2021, which established greater identification requirements for crowd control officers operating in large cities, namely identification on the front and back of uniforms. So the only change to that law is to include all law enforcement operating in Oregon within that existing law. So amendments have removed those extra requirements for all law enforcement, and it's simply that one form of identification. We have also provided ample time, 180 days, for agencies to implement or revise any policies. LEVA requires public employees to exercise greater caution and be sure that requests for information or assistance from federal or out-of-state agencies are not based on unconstitutional or discriminatory investigations. Based on feedback, we have clarified the scope of liability for public bodies and employees so that to be liable, an employee must intentionally provide assistance with the knowledge that the investigation is occurring on an unlawful basis. LEVA also now contains clear exceptions, allowing for cooperation in response to a court order, state or federal legal requirements, and publicly accessible or available information. We have also included a safe harbor provision to protect employees who obtain signed attestations from a requester that the information will not be used in a way that violates LEVA. The provisions related to joint federal task forces and cross-deputization agreements have also been refined to accomplish two purposes: to increase transparency into the agreements governing these joint operations and create a process to cease participation in the agreements if they will lead to unconstitutional or discriminatory investigations. This is because of how federal policy, including executive orders, has sought to weaponize task forces nationwide to fuel not only mass deportations, but the targeting of individuals and groups for exercising their rights to free speech or simply caring for an undocumented family member. These restrictions will only apply to agreements entered on or renewed after the effective date of LEVA, which gives agencies abundant time to review and assess their participation in these task forces. And a safe harbor provision and exceptions for cooperation pursuant to a court order, legal requirements, and publicly accessible information are now included here as well. Finally, accountability is provided by a cause of action for injunctive relief modeled on the Sanctuary Promise Act, rather than monetary damages or criminal sanctions of any kind. It allows any person to seek a court order against an agency, not an individual, to stop or prevent a violation of LEVA. Thank you.
Great, thank you.
Chair Cruff, apparently Vice Chair Wallen left again. Vice Chair Choatson, members of the committee. My name is Nick Hunter. I'm the Marion County Sheriff, and I appreciate your time for letting us come here and speak on this issue. I'd be remiss, and we have to start out with thanking Representative Chaichi and her staff. They have been working with law enforcement. I know we've been working on amendments, trying to come to an agreement of what this looked like. And we may not be there yet, and that may be why we're here today, but we wanted to acknowledge the work and the collaboration of trying to get this done. It puts me in this interesting position of I'm here today in, I don't know if this is going to be a new term, but I'm going to call it positive opposition. That's where we fall in this. And one of it is the realization from law enforcement of there is a real challenge that is going on right now with the execution of federal law enforcement and how that is being conducted. What we don't want to lose, though, is that where this is aimed is at federal law enforcement, and your local and state law enforcement are doing things right. They've continued to do things right. I got the great opportunity to come in and talk to the joint judiciary, and we talked about this and talked about uniform requirements and talked about professionalism and how important that is to your state and local law enforcement. Contrasting colors. Our uniforms are clearly marked, and unless it is a special assignment, you are always in uniform. This is not what's coming from our local law enforcement. And so we want to be thoughtful about this. If we look at 4138, this is extending additional requirements, and it was said on top of House Bill 3355, and really now trying to apply that generically across. It also comes with additional penalties of an A violation if there is some sort of a masking type incident. Sorry, Mr. Chair, can I have about another 30 seconds? Sure. Thank you, sir. So with that in mind, we want to be careful of the message that we are sending to our local law enforcement and our state law enforcement when we're bringing them into this, and they are really doing things right. They are paying attention to 181A and what that says and what we can do. It was mentioned about task forces. Several of our task force partnerships, collaborations, those are absolutely for the greater good of some very significant crimes that are occurring in the state of Oregon. It has nothing to do with the issues that is bringing us here today, but this starts to put a temperament confusion on how we can participate, even a prohibition on some of those about how we can participate. So we just want to remain thoughtful about how we are applying that and that we are not taking away tools from our local folks. I know there are exceptions to the masking requirement, but we need to be very careful about what those exceptions look like. Ensure that they are not from someone that was trying to violate this. I've heard anonymity and these other pieces. We've never tried to be anonymous. We are actually required to provide the name, the other information. I heard something about the protests. We are already through 3355 wearing a unique identifier, and we have implemented that across to ensure that we have the transparency and the accountability that's being asked for. So again, I want to be careful, and I want to make sure that it is positive opposition, because I think there is a real challenge here that is being addressed. But I want to ensure that we are also being thoughtful for those good men and women that are being transparent, are being accountable, and are doing those things already, that we're not sending them the wrong message. And so we would like to continue to work through this. I know there's some amendments already out there, and that's where we'd like to be. So I appreciate your time. Thank you.
Thank you, Sheriff. Adrian?
Yep. Chair Krupp, Vice Chair Choatson, members of the committee, my name is Adrian Anderson. I represent the Oregon School Boards Association. We represent all the school districts, education service districts, and community colleges in the state. So I am going to steal the term of positive opposition, but particularly we are in opposition to sections 8, 9, and 18 in the -3 amendment. I think it's 12, 13, and 22 in the base bill. As far as public bodies, and in this instance, school districts, assisting or working with federal law enforcement, there might be a number of instances where a school district will work with federal law enforcement, whether that's for child sexual abuse material or a threat is called in, or the number of reasons why a school district would either be working with federal law enforcement or in tandem with local law enforcement and federal law enforcement. And I think these particular sections really just kind of will have the effect of making our districts and our administrators kind of terrified to work with federal law enforcement, because they might not necessarily know when they are not violating this particular statute. And particularly if the idea is for school districts or public bodies to exercise greater caution. And I think I heard one of the proponents say when they are cooperating, they can ask federal law enforcement or any law enforcement, what is this investigation for? Is it for someone's Article 1, Section 8 First Amendment rights? Are you violating their search and seizure rights? And the law enforcement officer will likely say this is an ongoing investigation. We cannot provide you with any more information. And so that kind of really puts school districts in a sticky situation where they could, face potential liability. I do appreciate the mental state change, although that does not change my concerns. And I appreciate the removal of the private right of action. I share the same concerns with an injunction. That's still going to be attorney time. It's still going to be court time. And with the injunction, I'm just going to finish my sentence with the injunction. If a school district is enjoined, let's say someone's, Fourth Amendment rights were violated, does that then put the school district on notice where if next time, that satisfies that knowledge component, even though they might not know why someone's Fourth Amendment rights were violated? So I think that there's still some work to be done with this bill. I think school districts right now are being pulled in a lot of different directions. Their budgets are being cut, and they're trying to protect their students. And I just don't want an extra thing to be placed on them. So thank you for the opportunity to testify, and thank you, Representative Chaichi, for meeting and discussing this bill with me.
I think Representative Choatson has a question.
Thank you, Chair. Thank you so much. And Sheriff Hunter, this question's for you. Your testimony in legislative days, I think it was back in September, was really impactful about the reasons why Marion County doesn't just follow the law, but really exceeds the law in Oregon about identification and masking and all that. In your law enforcement experience, do you feel like our community would be safer if all levels of law enforcement of all types were following that same type of policy that Marion County sheriffs follow?
Chair Krupp and Vice Chair Choatson, I appreciate the wording for your question. So law enforcement, when it comes to any law enforcement, first of all, it comes down to the task that you are trying to do. But the 98% of those tasks, clear identification from the very start will always help whatever that encounter is. There shouldn't be any question. I don't want a question when my folks show up on scene, that it is law enforcement showing up, and I prefer that you can actually identify the fact that it is the sheriff's office. So I think there's a lot to unpack with what you said, but the short answer is I will support you and absolutely say yes, clear identification on the front end will always help with the potentiality of better communication and outcomes.
Thank you.
I just want to put, thank you, Chair, put your worry at rest. We took the violation component out in one of the other amendments. There's been a lot of negotiating, so there's a lot of moving pieces. Sorry we didn't make that clear beforehand.
Thank you. Aaron, you're online, please.
Can you hear me?
We can.
Thank you, Chair Krupp, Vice Chair Choatson, and Vice Chair Wallen, and members of the committee. My name is Aaron Schmautz. I am the president of the Oregon Coalition of Police and Sheriffs. I apologize for not appearing in person. I'm in Washington, D.C. I also did not have a time to review the most recent amendment. So to Representative Chaichi's point, these concerns in this ever-moving conversation are based on my current knowledge. I want to thank Representative Chaichi and her staff for their thoughtful and consistent engagement on the topic of this bill. These conversations have been remarkable and encouraging, and while we have been unable to find a pathway to supporting this legislation as it currently stands, I believe that this process is a demonstration of different perspectives seeking a positive outcome through listening and engaging, and I hope to encourage these kinds of productive conversations in the future. I and all law enforcement officers understand how complicated these conversations are, and we're deeply committed to protecting our communities with accountability and transparency. I won't repeat the points made by Sheriff Hunter as he correctly identified many of our concerns, but I do want to say that we have seen in recent days that I believe the appropriate venue for many of these conversations is in federal court and with our Oregon delegation in Washington, D.C. Oregon law enforcement has robust identification laws for law enforcement. Our officers use protective equipment when needed, but it is simply not possible for a member of Oregon law enforcement to avoid identifying themselves. I recognize community concern, but I also fear that this legislation will suggest to Oregonians that there is a problem that needs to be solved as it relates to Oregon law enforcement. As it is still written, Oregon law enforcement cannot support this legislation. The sections of the bill would absolutely have a cost on agencies, particularly smaller ones. It will not have an impact on federal agencies. I'll note that I understand as it currently stands, the California masking bill has been stayed pending review, and it could have a serious impact on intergovernmental and partner relationships, which will not make our communities safer. Representative Chaichi that our community wants to be protected and is asking for reasonable questions and has reasonable concerns. I just ask that we recognize the hard work that this committee and that our legislature has done over the last decade to provide the very protection and the transparency that we're seeking today. Thank you.
Thank you, Aaron.
Hi, everyone. Chair Krupp, Vice Chairs Choatson and Wallen, and members of the committee. My name is Marisol Mora. I am both a proud Oregonian, having lived in this wonderful state for the majority of my life, and I am equally a proud Mexican immigrant. I am also here as the Advocacy Director of Next Step Action Fund, a youth-focused organization. Growing up in Salem, I can vividly remember the topic of law enforcement, specifically federal agencies, being one that caused innate anxiety. This was a hushed topic, yet the anxiety was very pervasive. Today, the same anxiety is being felt by thousands of Oregonians across the state, whether they are directly or indirectly impacted by the violent immigration raids happening here in Oregon. When one neighbor is forcibly taken from their community without due process, when one neighbor is threatened for simply exercising their right to observe, when one neighbor is missing for weeks or months without a trace, that affects us all. The actions of masked federal agents are an act of power without oversight. The piece that I want to focus on today as an organization that works with young people is the part of House Bill 4138 that prohibits employees of public bodies, such as public universities, from intentionally assisting in operations conducted by federal or out-of-state law enforcement agencies engaging in unconstitutional searches or seizures. Oregon has also experienced a rise in targeted attacks on international students whose visas have been revoked by the U.S. Department of Homeland Security without cause. It is vital that students know they can trust that their university will not intentionally cooperate with these agencies and that public employees are assured they can refuse to cooperate with unconstitutional demands. We urge you to pass House Bill 4138 to reinforce that Oregonians have a right to safety, transparency, and accountability. Thank you for your time.
Thank you, Chair Krupp, members of the committee. For the record, my name is Scott Winkles, representing the League of Oregon Cities. We are officially neutral on this bill. I will say that we received the amendments this afternoon, and I'm analyzing them on my phone, doing our best to redline the changes in the bill. I do want to thank Representative Chaichi and her staff and the ACLU for their thoughtful engagement in addressing some of our concerns with the bill. I think one of the initial concerns we had with the bill was the message that the language could potentially send to Oregonians. I would like to say on the record, we can find no instance of a city acting in outside of in violation of the Promise Act or any other Oregon's prohibitions on the enforcement of immigration law. I would also say that we cannot find instances of Oregon police officers, and certainly not city officers, masking or concealing their identities or acting outside of accordance with the changes that we made to policing in 2021. What I have witnessed from our members is a deep concern over some of the tactics and the alarm that is created in our community. We have a number of cities who are looking at how to respond locally to those practices. You know, we are hearing we should not have a scenario where a person who was taken into custody, we're getting a kidnapping report on a person who's taken into federal custody, and that we know that has occurred. It is our intention to stay engaged on this conversation to ensure that amendments are functional and act in a way that is intended by the sponsors. We have not done, we will still have to do, as we are required on all bills, a thorough fiscal analysis on section by section. We will do that accurately and to the best of our ability, and we will always have a number that we can defend.
Thank you very much. Chair Kopp, Vice Chairs Wallen and Choatsen, and members of the committee, my name is Michelle Glass, and I thank you for the opportunity to testify today on behalf of So Healthy, which is based in Medford. We're one of 9 regional health equity coalitions, or RHECs, across Oregon. We work to advance health equity, well-being, and safety for families in Jackson and Josephine counties. And that's why we urge strong support for House Bill 4138. As I'm sure you're all aware, health equity depends on people being able to live, work, gather, and seek healthcare or social services without fear of intimidation, surveillance, or misuse of public authority. Our communities depend on your leadership to ensure safety through clear, accountable measures. Your support for HB 4138 would strengthen those conditions by requiring clear identification of law enforcement officers, limiting anonymous police practices, and preventing misrepresentation of law enforcement authority. These measures help ensure that people know who is exercising power over them and under what authority. Between September and December of last year, we surveyed families across Southern Oregon about their top concerns. Threats to human and civil rights consistently ranked among the top 3 issues, alongside housing and cost of living. HB 4138 directly responds to those concerns by establishing clear accountability, transparency, and enforceable protections when constitutional rights are at risk. The LEVA Act moves beyond aspirational policy by creating real enforcement tools, although I hear that some of those are under consideration with the amendments, but I hope they stay, by allowing people harmed by violations to seek real redress. HB 4138 aligns strongly with our local community's stated priorities and with the conditions needed for people and families to be safe, healthy, and able to fully participate in our community life. We urge the committee to support the bill and to move it forward. Thanks so much for your time.
Thank you so much. Members, with that concludes the people who have signed up to testify on House Bill 4138, and I will close that public hearing.